Welcome back to Jawabu Talk, here for you. I believe you had a great week, and of course you were able to watch our video for last week on succession with Madam Winnie, and I believe you've received a lot of insights. I believe there's a lot of light that has been shed on issues and matters succession. Okay, so Winnie, welcome back.
Thank you, Regina.
Day 2. We must create awareness so that our people can get help and we are not ignorant. And you remember the scripture we shared, Proverbs. Listen to advice and accept instructions. In the end, you will be wise.
Sure.
In the end, we are all going to be wise. Now, we were talking about the will, preparing for death. You talked about the written will and the verbal will. Explain to us about that, and you can also greet the viewers.
Wow. How are you, viewers? It's good to have you here. And just to continue where we had left last time, and I think I'd mentioned that we have 2 types of will. Yes. You have what we call the oral will and the written will. I know most of the time people know of the written will. Yes. Actually, the oral one, it can also be made by a testator. Testator is the person who makes a will. So an oral will, however, when made, it must take effect within 3 months. What do I mean? Is that when you make an oral will, and within 3 months, you should have gone or met your creator.
Okay.
Yes.
All right.
It cannot take effect after 3 months unless you're working in the armed forces.
Please explain that.
When I talk of the armed forces, their oral will is extended on the basis that during that period you make the oral will, you are in active service. Let's say the KDF. Okay, they have gone for war, and during that particular time, you make that oral will to your friends and say, this is how I want my property to be distributed upon my demise.
Yes.
So that if you are in service for 6 months, then that will still be valid, notwithstanding that the law had expressly stated that an oral will should take effect within 3 months from the date when it was made.
Okay.
If you're not in the armed forces and you make an oral will,
Yes.
and within 3 months you are still alive,
Yes.
because of course a will takes effect upon someone's death.
Yes.
So within 3 will, when once you've made an oral, from when you made an oral will,
Yes.
that will is not valid. It's no longer valid. It expires.
It expires.
You either now must make another oral will or now revert to a written will. What you also must know is that when you make an oral will and then later on you make a written will, or you make a written will and then later on after the written you now follow it with an oral,
Yes.
meaning you're trying to amend the written one that
yes.
you had done before or you had made before. Written will always takes precedence. Written will, anytime there's an oral and written will is what will be considered. That must be very clear. So how is a valid oral will made? You must make it before 2 witnesses.
The written.
For both the written or oral.
2 witnesses.
There must be 2 witnesses who have capacity and who can come and confirm for the oral that I had the deceased distributing his property in this particular manner. And they all must say the same thing. So that if they contradict each other, then that oral will be invalidated. So they must all say the same thing, no contradiction. It must be clear. But anytime there's a contradiction, the will be invalidated and will resort to now intestate succession. This is as if this person died without a will. And of course, now the rules of intestate succession will apply. And now, for the written will, of course, also again the basic. How can you make a written will? Because we've had instances where a will is also challenged in court, and this happens
most of the time, yeah.
Yes.
Yeah, most of the time.
So one of the most important thing when creating a will, you must ensure the basic elements for a valid will. The most important element for the valid will are present. What are those?
Yes.
Of course, you're talking about the capacity.
What do you mean by capacity?
When you talk of capacity, and a child, under 18 years, you cannot make a valid will.
Alright.
Whereby you are 12 years and you say, now I want to make a will. You must be of sound mind.
Okay.
When you talk of sound mind, it means that you're not making a will when you're sick. Your mind, and when you talk of sick, you can be sick, but your mind is in a position to make, to reason, to think, and apply to whatever you are doing. But if the person challenging is able to show that when this testator was making this particular will, he was not of sound mind. He was not of good mind. His state of mind was not okay for him to be able to make this will, then that will also be challenged. He's able to bring documents from the hospital to show during this particular time his mind was impaired, then definitely that will be invalidated.
Wow.
And also, the will should not be made through coercion.
Yes.
There's an example where you find there's a brother who had stated that the deceased made a will, and it was clear that during that period when this will was made, this deceased was staying with the brother, and the deceased could not walk. He depended on the brother. He relied on the brother. Yes. To carry him, to take care of him. So the person who challenged this will actually said that this brother, who was actually also a beneficiary in that will, coerced the deceased to creating this will. And as a result, because of that coercion, and the coercion was because of the role he was playing in the deceased's life, so the deceased signed it out of coercion to impress him. So that will was successfully challenged.
Oh, so is there proof? Can somebody document evidence that one has been coerced?
Now, the person challenging it, you're the one to come and prove to courts and convince the courts.
All right.
For example, if this, like the case I've given you, if indeed there are people, either from the family, friends, it can be neighbors, who will actually come and confirm, yes, this deceased was staying in this house. They can come and confirm, yes, this deceased could not walk. He depended on the brother, who is also a beneficiary in that particular will, to carry him, to support him. You see? So when all this evidence is brought before court, and the court is able to clearly see that there is an element of coercion from the part or the side of this particular brother or the person presenting the will, then that will can be invalidated. So an element of coercion should not be present when that will was prepared. And then also, I'm just trying to mention the basic principle. There must be witnesses in that will when it is drawn, so that a testator, or when I talk about testator, the person making the will, you cannot sit down and prepare a will and then you just sign without witnesses. There must be at least 2 witnesses. So
with capacity.
Yes, all those witnesses must also have the capacity. They are not children, they are adults. And all those witnesses must be present when you're signing
at the same time.
that will. They must see you signing the will, so that you cannot send the will and then they say later on, I was given that will and I signed. You're coming to confirm, I saw this testator executing the will and I actually witnessed it.
Okay.
So that's what we call attestation. There are instances when you're doing that will, you want your witnesses to be, let's say, your beneficiary, who might be your children.
Yes.
So that if your children are beneficiaries in that will, and you want them to also attest or witness that will, you must also involve 2 other independent witnesses who are not beneficiaries.
Okay.
The Succession Act is very clear on that. Because if you don't involve independent witnesses, then that will can successfully be challenged. And then there are other elements when preparing that will. If there are no what we call actually executors in the will, we have executors. In testator, we not have administrators. Yeah. So the testator normally appoint executors. Who are executors? Executors are the people who are supposed to implement what you've said in the will. Like they are watu wako wa mkono to ensure that what is in the will is actually done. So those executors, it's not a must for them to be beneficiaries.
Okay.
But they can also be beneficiaries. You can say my daughters who are benefiting from my will, they are also going to be my executor. That is okay.
It's okay.
And then it's not a must you also bring another independent executors, like how we've said about attestation.
Yes.
Attestation, if you put your children who are beneficiaries in the will, you must bring other independent. But if you put your children as the executors, you don't need to bring other independent executors.
Okay.
They'll be beneficiaries, and at the same time they can also be executors. However, there are times people forget to appoint the executors. Now, the beneficiaries can agree who the executors of the will be, or if not in agreement, the court will decide.
Okay.
So what will happen when this person or the testator dies? This will and the will together with the petition that we had discussed in our earlier presentation, you make the petition in court, you file the documents in court for purposes of the court granting you letters of probate. Letters of probate and the will with the will annex. So those letters of probate will be granted, and it will take 6 months for it to be confirmed. The reason why it takes a period to be confirmed is so that if there's anyone objecting, challenging, they are given that time. And it's usually gazetted. That is now in the tested succession where the will is there. So it is gazetted. Anyone who sees in the gazette or is informed, then they have the right to go on.
Okay. All right. Wow, that is quite something, yeah? Good education there for all of us. Thank you, Winnie. Thank you, Winnie, for that. Now, Winnie, polygamous family and the extended family, that is also a bone of contention. Please explain to us the processes, especially for our polygamous. In the African context, we can't run away from it. It's reality on the ground. So polygamous family is there, the extended family again, they want to come and be part of the beneficiaries of this estate. So what do we do about that? What can we go around it? How can we go about it?
Okay. I'm sorry, there's something I remember that is very important that I need to also mention. Please remember, if you make a will before you marry or you're married, once you enter into a marriage, that will is invalidated immediately. The will you can never use it, can never be used in court.
Explain further.
It is presumed when you marry or enter into a marriage union, you are expected to write another will.
Oh, okay. Because of the new party?
Yes, because of the new parties.
Okay.
And basically the law of succession has a history, and it really values the family unit. And they're actually also very strict in terms of ensuring at a testator, or when someone dies, you do not stop or fail to support those you are expected to support. For example, a parent is expected to support their children.
Yes. Expected.
Whether you like it or not.
Yes.
It's the responsibility of a parent to provide the basic needs of a child.
Yes.
So that the succession, and that is in the Constitution, the law of succession will not come in and say, now that you made this will when you are single, and in this will the children have not been mentioned, and you are now dead, it will remain like that. That will automatically be invalidated by virtue, or it will be revoked. Actually, let me say, the word is actually the revocation of a will. A will is revoked through marriage. So if any single person has done a will, just know the moment you marry, it is revoked, automatic.
Okay.
Yeah, that one I think it's important, and most people imagine that since I have it in place, maybe it can still take effect upon my demise. The other question you've asked about polygamous, and extended family. Let me begin by for polygamous relationship. We are talking of where the deceased had more than one wife.
Does it apply for more than one husband?
Yes, of course there is usual, but in African setting, very rarely you'll find that there's a wife with more than one husband. So that now, because of what has been happening, I'll begin with where you find a man with more than one wife. More than one wife.
Yes.
So what happens during succession? The children in these houses are treated as units.
Okay.
I will give an example. We have house number A. It has got 10 children. And house number B, it has got 3 children.
Yes.
So the units are 10 plus 3 are 13 units. So each child is taken as a unit.
Okay.
And then if there is any surviving spouse, she is also added as a unit to the house. So house number A with the 10 children will have now plus the surviving spouse 11 units.
Yes.
And house number B with 3 children plus the surviving spouse is 4 units. And then now the wealth that has been left behind by the deceased will be distributed according to the units.
Oh, so each individual is a beneficiary.
Each individual is a beneficiary. There is nothing like bibi mkubwa na bibi mdogo.
Ama watoto wengi, bali hii ni wadogo wachache.
Yes.
Okay.
So each individual is treated separately.
Okay.
So that's why we are talking of as separate units. Yes. So that's what happens in polygamous setup. And then now for the extended. So for the extended now,
I'm looking at the case of Dr. Sibiri.
Yes.
That was the extended family.
You will notice even for the Dr. Sibiri, she was able to obtain orders to stop the in-laws from proceeding with this particular burial against her wishes. So as I mentioned earlier, there's an order of priority in terms of who is given priority even in succession. And section, I think, 27 or 28 of the Succession Act, it begins by talking who dependents are, and starts with the wives, children of the deceased, whether or not they're supported by the deceased. And then number 2, it goes to mother, father, stepmother, stepbrothers. And now those are the ones we're talking about, the extended.
Yes.
And it goes further to say if they were being supported by the deceased. So you see, when you're talking of the dependents, these are the people that can lay claim.
Yes.
Yeah,
Mostly they do.
Yes, to the estate of the deceased, and of course it also includes the rights to burial and all that.
Yes.
So priority to the right of burial, of course, is usually given to the surviving spouse. While the surviving spouse is not there, it's given to the children. Where the children are not there, let's say the deceased are not left any children, it's given to the father. Where the father is not there, it's given to the mother. Where the mother is not there, now it goes brother, sister, children of the brothers, children of the sisters, until to the sixth order of they call it I'm unable to pronounce, but there is a sixth order, but it follows that chain. So, when an extended family, you find maybe the father wants to come and lay claim in terms of, let's say, the burial place, and there's a wife who is still alive, then priority will definitely be given to the wife. The wife will be allowed to say where where she wants the husband to be buried. We have a case that is very notorious. If for those who can remember of Wamboyo Otieno.
Yes.
But that law has over time been mentioned as a bad law. Actually, it's one of the worst laws that has been made in succession. Because you see, this widow was denied to bury the husband.
Yes.
Yeah.
In Upper Matasia.
Upper Matasia, and they were taken to the rural home. But that was bad law. What the law has since had a better decision, which gives priority to the wife, so that if the wife says, this is where I want my husband to be buried, then she'll be given priority. I've had example, even a recent one, and of course it was a follow-up from our previous presentation that we had on the rights of widows in succession. And actually, almost a week after that particular presentation, I received a call from, it is actually a client, and this particular client, they had lost a loved one, and during that particular, it was a parent, actually, and this was the only surviving parent, because the other parent had died earlier. So this was the only remaining parent, and upon her death, the children, she was a widow. The deceased was a widow, so that means the husband had earlier passed on and buried in the rural home. So, but what had happened previously is when the husband died, the husband's side or the relatives, they linked or did not assist this widow. So they were not in the life of this particular family. And most of the time they do that because they want to disinherit this widow. Of course, the rural home, there's usually the ancestral land. Because if this widow is in their lives, it will mean you'll be entitled to allocate some land to her, so that at some point she'll also be able to allocate it to the children of this deceased husband. So what they do, they lock her out so that you'll never lay claim. And you see what happens. Most times, these women, because of what they go through, sometimes are not able to succeed. Because of frustration and the hardship. Some are not empowered. So they struggle in life, and even at times they end up dying early. But the good thing is that this particular client that I'm talking about, because I was involved, the widow was able to make it well in life. So this extended family wanted to make use of this opportunity to, as usual, and I don't know what normally happens, especially from my side. I come from Western, so, and even the famous case of Wamboyo Otieno, it was true Western and Nyanza. That is where we normally have the notoriety of claiming, the body and the issues of burial. So they wanted this lady to be buried in the rural home next to the husband. But you see, the children are very clear. We have no association with the rural home where our father was buried, because since our father died, we even don't have a house there. We don't even, if at all we are to conduct the burial there, where are we going to stay? And we feel that our mom had set this home She had expressed herself that she loves our
She
home.
had expressed herself.
Yes, she had expressed herself. During their conversation,
Yes,
and they could feel this is where she loves most. So we had to have a sitting, and many they will call the wazes.
Yes.
For mostly it's for purposes of intimidation. Yeah, and you see, if
and a lawyer
exactly
is always there.
Is always there.
Yes.
So if the children or these dependents they don't know their rights, you can easily accept because of the pressure or agree to their demands. But when you are able to bring a professional who will guide you, which we did, and the good thing is that the wishes of the children or this clan that we are representing, together with their deceased mother, took precedent. They were able to bury or took the day. Yeah, they were able to bury this parent at the site that she wanted to be buried.
Awesome.
Yeah.
Awesome.
So those are the challenges that come with the extended family. And I remember among the other things I mentioned is that over and above even the burial, now there's the issue of the properties. Yeah. In the urban setup, women are enlightened, but unfortunately in the village, they're either not empowered, or even if they're empowered, they cannot access justice. Yeah.
They cannot access justice. You've just mentioned that the old men come with a lawyer to intimidate her.
Yes.
So unajua, they also fear.
Yes.
They fear because probably these are our wazes. We need to respect them, give them their place. So those things.
Yes, and just like what Dr. Simbiri had mentioned, for her, by virtue, we expect by virtue of her being a doctor, definitely she's informed. And you can see she was able to ensure that the wishes of her husband, are able to be fulfilled. Otherwise, if she had not done or gone to court for those orders, the husband would have been buried where she did not want. Yes.
And now, like, for example, the person has been buried. I had a case some years back. A friend, she came and told me she found the husband was buried. Where did they get the ID? She had no idea. She knew she had the original ID. Unfortunately, that was up country. So basically, she was kicked out. Yes. What would you do in such an event? Because she was really hurt. She didn't know what to do. She didn't have money to go to the lawyers. What could she have done? And there are those things.
Cases where you find that your loved one has already been buried, if your spouse has been buried where you did not want, you can still go to court and get orders even to exhume the body. Of course, that is usually the worst case scenario. But if you actually feel and you're convicted that this is what you want for your spouse and this was the wishes for your spouse, you can. It's never too late. Yeah, it's never. And actually, it's a lesson to the other people around there that you proceed with these traditional beliefs, that it's always using force or just doing whatever you feel that you want because you are wazes.
Yes.
Yeah, it's also a lesson that now we have the laws in place, and these laws, whether it's never too late for them to take force. Yeah, so it's possible that we've had many cases. Body is exhumed, and you'll be able to bury your loved one where you want him to be buried.
Great. Now, Winnie, you've mentioned about the will being oral or written, and now the person. Let's take an example of a widow. The husband has passed on. What is she supposed to prepare for the burial? What documentation is she supposed to have so that she has legality over the whole issue?
One of the most important things, especially for burial, is what we call the burial permits. When a loved one dies, the hospital where the person died, or if it was at home, of course, you'll have to report that death.
Or if it was an accident.
Yeah, or if it was an accident, and a burial permit must be issued. That burial permit, when it is given to whoever it's been given, most of the time it has got the powers not to release the body. And that is where most, let me talk for women,
Yes.
because they are normally the easy target,
Yes.
because that time you're still mourning your loved one.
Yes, and even in shock.
Yes, and
really.
in shock.
Yes.
Without knowing that the people who have obtained this burial permit, they'll go take the body of the deceased
yes.
and bury. So one of the things is to ensure that you obtain the burial permit, and if you feel they are likely, maybe you are not so sure, but you feel that they are likely to go and take the body without your authority, just where the body has been stored, whichever the morgue, just issue those instructions that I'm the wife, I'm done with this burial permit, no one else will come and collect this body. However, where the body now has already been collected, now that's an issue of going to court for an order. And most of the time, when application is made, it can even be granted the same day. Orders can be granted the same day. But the most important thing is to show your relationship with this deceased. Yes, so that if you're the wife, it's always good to have some form of documentation, because now our court is all about evidence. You will not just go and tell the court, I'm the wife and I want an order to stop this particular burial. So you're the wife, what do you have? And that's why actually in 2010 we have got this amendments, the Marriage Act, Matrimonial Causes Act, and like in terms of the registration of marriage. All marriages are supposed to be registered. So that, and of course a certificate issued. You see, those are some of the documents that can assist you when you are faced with such a scenario. Because see, if you don't have, let's say maybe you're in such a case and you don't have, it can be even the birth certificate of your children, which indicates that
birth certificate.
Yes, copies, yes, evidence. If you're able to connect what the relationship between you are there. So the birth certificate, of course, it shows and indicates the deceased, the father, and it shows your name, your name there. If you have got photos that you are taken with the deceased person, if you've got the proceedings of this customary
evidence, like Dr. Simbiri went for an obituary.
Exactly. We're talking of it. You will just not go with your hands and say, I'm the wife. You'll have to provide evidence. So those are the important documents that you'll need if at all they've already taken the body and feel they're going to bury without your consent of the location.
Great. I believe we've really learnt a lot today. We cannot exhaust the questions or the wishes of you as our viewer, but I would wish Winnie to tell us, where can we find her? How can we locate her? Because I know most of us want her help. You can tell us.
Thank you, Regina. Actually, you can find me at Assumption Center. My office is at Assumption Center. For those who don't know Assumption, it's in Nakuru. We have a famous hospital called Mercy Mission Hospital. I think it's the most famous hospital in Nakuru after PGH. So, and the building is owned by the Catholic Diocese, CDN. So we are located there at second floor, Ashitiva Advocates. If you're in Nairobi, of course, we also have Ashitiva Advocates, still the same firm, and it's in Upper Hill, Victoria Towers, and Gigiri, Warwick Center.
Warwick
Center in Gigiri. So that's where you can find us.
All right.
And we'll be more than willing to assist.
Do you want to give us your contacts, really?
Yes, no problem. My number for those who will be interested to reach me is 0720 712 194.
Repeat again.
I can repeat. 0720 712 194.
Awesome. It's been so nice to have you, Winnie.
Thank you, Regina.
On set. I have learnt a lot. I'm no longer ignorant. And thank you, our viewer. And we consistently commit you into our prayers. Do not forget to like, comment, subscribe, and even share with your friends. Our contacts are on the screen. Get in touch with us, and we assure you of confidentiality. See you next time. God bless you.